Good afternoon. Welcome to Division A of the Court of Appeals. My name is Judge Furman. This is Judge Dunn, and this is Judge Welling. We have one case on the 1:30 docket, people in the interest of LRB. The attorneys, it looks like, are ready here and remotely. Is that correct?
Yes, Your Honors.
You should have been provided with a handout of our procedures, but I'll just highlight, because of the nature of this case, counsel are directed to not disclose the names of the children or their parents or any identifying information. We're live streaming the argument, of course. If anyone has a cell phone, please make sure it's off. And there's three of you on one side. You understand you'll have to divide your time, right? All right, well then, let's go ahead and get started.
Thank you. May it please the court, Andrew Fitzgerald, attorney for the Navajo Nation, Utah 8944. If this court recognizes the name of this case, it's because it's been before this court before. This court affirmed the termination of parental rights regarding the paternal father not too long ago. The significance of that is that during the pendency of that appeal, the Navajo Nation filed its first motion to transfer jurisdiction. The lower court ruled at that time that it didn't think it had jurisdiction because jurisdiction was here, and said that it couldn't transfer jurisdiction, but would consider it at another time. So likely it wasn't a final order, as the judge was saying, I'll consider it another time. This court affirmed the lower court's termination, and shortly thereafter, the Navajo Nation filed its second transfer of jurisdiction. Transfer of jurisdiction 1 and 2 were both stipulated to by all the parties, the department, and the Guardian Ad Litem's office. Subsequent to that, the foster family filed a petition for adoption in the lower court, and the parties, GAL, the department, and the tribe, filed motions to dismiss, and the judge, pending with the second motion to transfer, and the judge set it off for a June 25th hearing where he was going to take evidence.
Mr. Fitzgerald, sorry to interrupt. Did the judge enter an order joining the cases, the DNN case with the adoption cases?
He did consolidate the cases, and it was interesting because the judge there was no motion for that. The parties really weren't able to respond to it. It just sort of happened, I guess you could say.
Okay.
And
Mr. Fitzgerald, along those same lines, was there any objection filed at all in relation to the consolidation or the joinder, any by the department, the JL, or the Navajo Nation?
There wasn't. At the time we had pending motions to dismiss,
okay,
and the motion to transfer that was stipulated to, and really had no objection to it.
Sorry, let me follow up with some more. The motions to dismiss governed just the DNN case, or all of the cases?
It governed the adoption filings that the foster family filed, and it also, as part of the transfer, asked to dismiss the Colorado jurisdiction and transfer to the tribe.
Okay.
So we got to the hearing on the 25th of June, and the tribe objected, renewed objections on the second day of the hearing, objected again based on standing. That, in essence, arguing that the foster family couldn't put on evidence, couldn't object to the transfer because they had lost standing approximately 10 months prior under Colorado statute. The Colorado statute is very specific about what constitutes standing, as we've always briefed. I don't know if it's necessary for me to go through that again, but the judge applied other standards to grant some form of standing to the foster family. One of that was a permissive joinder under Rule 20, and the tribe objects to that because that would conflict with CRS 19, et cetera, that put specific standing requirements for foster families to have standing in a case.
I think you're referencing 193507, is that correct?
Yeah, that's correct, Judge.
So the fact that the former foster parents petitioned to adopt, how does that inform a standing analysis in the DNN case?
Well, so it becomes a separate case really under a separate filing, and it also requires.
Well, but if the judge joined the cases, we're dealing with everything together.
Well, I think that it was improper for the judge to do that. I think that the law doesn't allow that, and essentially allowed a party that was a stranger at that point to interfere in essentially the dependency case. It's not too different than anyone off the street saying, hey, I'm 21 years old of age, I can petition for adoption of these kids. And it's the same, and to allow them into the dependency case would be absurd. But essentially, that's what's happened. The only difference was this was a former foster family, but they hadn't had the kids for 10 months. They had no contractual relationship with the department. They had no current knowledge of the best interest of the kids or their current needs. And when they did have standing, when they were foster parents, they didn't object at that time when the children were removed for them, and then over a year passed between that time and when the adoption petitions were filed. And I think my 5 is probably up.
Will the county be arguing, or the GAL, or how are you gonna, if you could stop the clock for while I just ask these procedural questions. Is the county gonna be arguing also?
Everyone wanted 5 minutes, Judge.
Okay.
And I was gonna address standing mainly and
Okay.
move from there.
Because I was gonna ask you a question, but I can wait to ask the county then.
Certainly.
Okay.
I'll concede my time then. Thank you.
My name is Ian McLaren. I represent the Montezuma County Department of Social Services. May it please the court. And the specific issue that I'm going to address today and really hone in on is the issue of whether 25 U.S.C. 1911 subsection B applies in this case. In essence.
Well, could I interject, sorry to, because I'm going to ask an unrelated question to what you're teeing up there.
Sure.
Did the court give the department legal custody of the children in the DNN case? I mean, I assume, but.
Yes, Your Honor.
And what's the statutory authority when the department has legal custody? What authority then does the department have in making decisions for the children?
Well, certainly 19.3.405 speaks to the department gaining legal custody of a child, and it allows the court to grant legal custody of the child to the department. And so certainly at that point, once legal custody is granted, then we are allowed to certainly make decisions for the court. Now, understanding that the court is ultimately the ultimate judge and makes and governs some of the things having to do with the children in terms of placement and whatnot.
Well, as far as placing a child for adoption.
Your Honor, I'm going to have to punt on that. I'm not sure. I don't have the exact statutory authority in front of me. I apologize.
That's fine.
Mr. McLaren, before you start in, did the department actually file an objection to the petition for adoption filed by the former foster parents?
We did, Your Honor.
You did,
Yes,
in
we
the
did.
Adoption case?
Well, the cases were joined, and
They
so
were
we filed
joined,
them.
okay.
We filed an objection jointly into both cases.
Okay,
Yes.
thank you.
So, as far as whether the transfer provisions contained in 25 U.S.C. 1911B apply to this case, the district court found that they didn't, and in essence, in doing so, found that the good cause provision that would normally govern transfer proceedings didn't necessarily apply. The court did go on to find good cause. In this case, I think it's very clear that 1911B, 25 U.S.C. 1911B does apply in this case and would allow the tribe to transfer. In essence, that statute, the language of that statute is somewhat ambiguous in that that statute directly pertains to proceedings, that child custody proceedings. It does not include any language about adoptive proceedings or pre-adoptive proceedings. And so the court took-
Doesn't that make it somewhat clear?
Your Honor, I think that the statute is silent, and certainly, generally speaking, if a statute's silent, the court would just read the plain meaning.
But doesn't ICWA define child custody proceedings as for proceedings?
Absolutely.
And isn't adoptive and pre-adoptive placement among the
It is,
proceedings
it
that are
is.
explicitly identified?
Yes, well, all 4 proceedings are identified, but really 1911, subsection 1911B does not speak to, it doesn't say that, doesn't preclude transfer of those proceedings. It doesn't necessarily grant transfer of those proceedings. I think that
But
that's.
you would agree, sorry to interrupt again, you would agree that it states, I just turned to it here, in any state court proceed, and I'm quoting, for the foster care placement of or termination of parental rights to. That seems like 2 specific proceedings that does not, and they left out the pre-adoptive proceeding.
That is correct. The statute is silent as to pre-adoptive and adoptive proceedings. I would point the court, though, to the case of, it's in Reed 2001 District of Grand Jury. It's 97 Pacific 3rd, 921. It's a Colorado Supreme Court case from 2004. And that case says that the court will not strain to construe a statute unless doing so is necessary to avoid an unjust, absurd result. In this case, for the court to simply not apply transfer proceedings to adoptive and pre-adoptive proceedings would completely undermine the purpose of ICWA. Really, the purpose of ICWA was to avoid exactly what we're dealing with in this case, a situation where a state court prevented the tribe from making a decision that would be in the best interest of the children. I think that we really need to be aware here that tribal sovereignty and the tribe's ability to make decisions for their children, that's ultimately in the children's best interests. The studies consistently show that the tribes really are in the best position to do that and make decisions for their children. And ultimately, I think that any decision to the contrary, finding that the statute or transfer provisions don't apply, would undermine the very essence of ICWA. And
Mr.
I'm gonna-
McLaren, didn't the trial court just find it was discretionary, though? And isn't that what the Arizona Supreme Court did in the Gila case? Is that 1911B can be just a discretionary?
That is
For
what the
pre-adopted.
Arizona Supreme Court did, yes. And that's in essence what the trial court did in this case. I would argue, however, that 1911B should apply. I mean, I'm not sure exactly the statutory authority to find that it was discretionary, and that was something that the court sort of came up with in light of the broader context of ICWA, but I would argue that the specific language does apply. I'm going to yield the floor to the children's guardian ad litem at this time.
Okay.
Thank you.
Good afternoon. My name is Beth Padilla. My attorney regulation number is 43520, and I represent the best interests of the children in this case. I would like to discuss the issue of whether good cause existed for the trial court to deny transfer. It is my position that there was not good cause to deny the transfer to the Navajo Nation. Specifically, upon receipt of a transfer petition, the court must transfer the case unless there's good cause to deny the transfer, and that's 25 CFR 23.117.
Sorry to interrupt, let me ask this. Does 19.1.126, I believe it's 4B, create a presumption in favor of transferring jurisdiction?
Your Honor, I don't know if specifically that creates a presumption in favor of transferring, but I do think that the federal regulations do. I think that the federal regulation that I just cited indicates that the case must be transferred once a request is made. In this case, as already detailed by the Navajo Nation's attorney, they requested twice to transfer this case to a tribal court. The federal regulations are clear that the tribe may request transfer at any time during the termination proceeding. And as already pointed out by one of the members of the court, there are 4 different types of child custody proceedings, one of which is the termination proceedings. When the Navajo Nation requested transfer the first time, it was during the termination proceedings. The matter was on appeal the first time before this court.
Wouldn't you agree that the termination proceeding was on, and it was at an advanced stage, given that it had already been resolved and was on appeal pending disposition?
You know, I think that that's a difficult question. Perhaps it was at an advanced stage. The case was at the Court of Appeals for a long time and then came back down to the trial court, and then only at that point did we move into the next stage of pre-adoptive proceedings. And so I think that the termination proceeding, when we think about that traditionally in trial court, we think of the 2 or 3 days that were actually in the trial court. But in the context of ICWA, I think it's a much longer window.
Well, I think it starts with the filing of the motion and ends with the mandate, but you were already
agree.
through the hearing, right?
We were through the hearing, and it had been submitted to the Court of Appeals. The mandate was not issued, I believe, until March of last year.
So how many months between the point of the filing of the motion to terminate and when the tribe submitted its first motion?
I think it was close to a year.
Okay.
And did they receive notice very early on in these proceedings? So, I mean, this was not an issue of the advanced stage being explained by a lack of timely notice, right?
You know, the tribe was absolutely involved throughout the case. They did not intervene until after the termination hearing, but there was an ICWA caseworker assigned to the case who participated in staffings, even testified at the termination proceeding. So the Navajo Nation, at least the ICWA social worker, absolutely had notice of the proceeding for a very long time. From memory, I believe it was the fall of 2015.
And it's your position that it's not a significant time of about a year between the time of the filing of the motion to terminate and when the tribe decided to move to transfer jurisdiction?
I don't know that I would say that it's not significant. I'm not sure that if by definition 1 year is an advanced stage in light of how long the cases are pending both in the trial court and at the Court of Appeals. I think
The trial court, one of its findings was that it was at an advanced stage. How do we review that de novo, or is there some deference that's given to the trial court in applying that factor and making that determination?
And I see you're out of time, but go ahead and answer.
apologize.
And I'll give opposing counsel a little more time too.
Okay,
so.
I would submit that it would be reviewed de novo. Interestingly, when the court made that determination that it was at an advanced stage, arguably we were at the pre-adoptive stage, and we were only 34 days into that when the Navajo Nation requested transfer the second time. So the Navajo Nation requested transfer the second time 34 days after the mandate was issued from the Colorado Court of Appeals the first time. I don't think that's an advanced stage.
Okay, and I apologize, and given
course.
this is actually the most impressive job of dividing time I've ever seen when three parties are doing this, but one of the other findings that formed the basis, because one of the things we have to look at is whether or not the good cause factors were prohibited or not. Mm-hmm. And one of the factors that's not prohibited is sort of a forum nonconvenience analysis. And that seems to be, at least there was a recitation of that, but without really any meat on the bones. Is that enough to, because that is a non-prohibited factor, right?
That's correct. And so to address that, I actually looked up this morning the distance between Cortez and Window Rock, Arizona. It's 2 hours. Took me 7.5 to get here today. So I would say it's not that far initially as a threshold issue. And then the second component, which I think is important, is that the Navajo Nation was contemplating a placement out of state with a relative. And so we would have people coming in from different areas no matter what. So I agree that that's not a prohibited factor for the court to determine or to evaluate in determining whether there's good cause. But I don't think that 2 hours especially in Southwest Colorado or even in the Southwest United States, is enough to say that it's a forum nonconvenience.
Okay. And I apologize, but this is something that's been
Sure.
weighing on my mind. So this was stipulated to by all the parties that this side contends have standing. If the court had ruled that the foster parents didn't have standing, and there's therefore nobody there that took an objecting position, did the trial court have to accept the stipulation, or could it have really considered what it considered even in the absence of an objecting party, and why?
You know, based upon the case law cited by the trial court, I do not think that the trial court was required to accept the stipulation. I think that it's up to the trial court to make that final determination. However, our position is that all the parties that had standing were in agreement that it was best for the children for the case to be transferred to the Navajo Nation.
Is best interest of the children a consideration in transfer?
It's not a specific consideration in transfer according to the federal regulations, but it is an overarching component that we all have to evaluate as required by Title 19. So I think, especially from my perspective, most decisions that I make, if not all decisions that I make in these cases, have a lens of what's in the best interest of the children. And these are enrolled members of the Navajo Nation. These children are tribal children without question, and the tribe wants their children back.
Thank you. I appreciate your indulgence.
Thank you.
Good afternoon. Jill Carlson for the interveners. I will be referring to my clients as interveners throughout my argument today. May it
Ms.
please the
Carlson,
court.
I'll give you an extra 3.5 minutes on your time.
Thank you, sir. I'd like to first address a couple of what we would mean are misstatements made regarding the timing of things that were submitted by Attorney Fitzgerald. First of all, there was no written motion filed requesting transfer into this case. The first mention of it came in November of 2017, at which time it was brought up during a review hearing. The court at that time did indicate that he was divested of jurisdiction, but that he would consider such a motion upon the proper filing of a written motion. And we maintain that no such written motion was made until after April 16th of 2018, which was almost 2 months after the adoption petitions had been filed by the parties. So Mr. Fitzgerald had indicated that that transfer request was done prior to the adoption petitions, and that is factually incorrect. We'd ask the court to consider that. With regards to standing for the interveners, we maintain that up until November of 2017, even after the children had been removed from the interveners' care, they still participated fully in this case without limitation. They were still included on pleadings, they were still invited to hearings, and they did have information pertaining to the best interests of the children, as did all of the other parties and attorneys to the case. Review of the record plainly shows that even after removal from the home, no parties objected to their continued participation. And I believe that the Navajo Nation did have the ability to timely file a request to transfer prior to that mandate coming down. However, they failed to do so. And when they did, that this case had squarely transitioned to the pre-adoptive phase by virtue of the fact that not only were the terminations upheld, but at that point, a petition for adoption had been filed for these children.
Ms. Carlson, Ms. Carlson, excuse me. I want to talk about standing a little bit. When the when the children were removed and the foster parents were the kids were no longer in their care, I'm having a hard time figuring out what exactly their standing in the DNN case was. Was it statutory? Was it constitutional? What is your claim that the legally protected interest flows from?
I believe that the statute 193507 is silent as to what happens to remove fosters from a case. And I believe there's a case on point in the state of Colorado that addresses this issue, and that would be NRIght M 522 P 2nd 1234, wherein an adversarial department had removed children from foster home that they did not care for the foster parents. And in that case, the court still found standing because they maintained that they had properly intervened under 193507, that they continued to remain involved in the case, as did the parties in this matter, and that ultimately they filed a petition for adoption that was granted. And so I believe that the Navajo Nation, the GAL, and the department unilaterally making a decision that these parties were no longer parties to the case, as they did with their motion filed of April 16th, which they did not confer with us on, is improper and attempts to interfere with the role of the judiciary in determining who the parties are. I don't think that's something that the parties get the right to choose.
Ms. Carlson.
So I believe it's
Ms.
a mix
Carlson,
of case, sorry, sure.
let me just follow up. When you're talking about the NRA M case, when that's talking about what was some other statute, what we now have is 193507, did the statute at that time in the 70s, I believe, read the same way it does now as far as intervention?
I believe the language is different, and if I recall correctly, sir, I believe what was added to the new version of the statute was the provision or the clause that requires foster parents to have the children in their care for greater than 3 months. That's my understanding, sir.
And did the Supreme Court in CWB clarify what this intervention role entails and what standing foster parents have, including pre-adoptive foster
sorry.
parents?
Sorry,
Go
I
ahead.
didn't mean to interject.
That's okay.
Yes, I believe they did. However, we have to look at the role of the interveners after the adoptions filed, or adoption petitions were filed, as a different role. The department wanted them to no longer be foster parents, and that happened. And so they may have lost their standing as interveners. But there is no limitation aside from age on who is allowed to adopt. And after there was no movement on this case with these children, and there was continued review hearings that the foster parents, as they were then, were allowed to participate in, they made the choice to follow under 19.5202 and exercise their right to petition the court for adoption as individuals who were over the age of 21. So I do not believe that CWB applies to this case, because the foster parents now petitioning adoptive parents were no longer considered foster parents. So I think that case is completely inapplicable to the case at bar. Would you like me to continue on the standing issue, or do you have any further questions, sir?
I don't right now. Thank you.
Okay. As to the standing on the appeal, which was raised not in, I believe, the Navajo Nation's brief, but the brief of the department, I would just argue the same, that basically CWB does not apply. At the point that my clients petitioned this court for adoption, the case had transitioned to the pre-adoptive phase, and they, the statement was made, they're no different than anyone off the street. Well, that's partially true, but that's not a requirement under 19.5202. Any individual off the street could have filed these petitions to adopt, but what makes this case different is that these parties, my parties, were allowed to continue to participate in the proceedings. They continued to receive information, they continued to receive discovery, and up until April of 2018, when the other parties decided they didn't want to include them anymore, they were receiving all pleadings. That was the first time that this happened.
Ms. Carlson, sorry to interrupt again. Let me just refer you to some language in the CWB opinion.
Yes, sir.
The Supreme Court said, first, we disagree with the Court of Appeals that the foster parents have suffered an injury in fact, inasmuch as they were arguably positioned to adopt the child in the event that the mother's parental rights had been terminated. So in this CWB, the foster parents were in a pre-adoptive role. The court went on to say that at the time of the appeal, the foster parents' ability to adopt CWB was speculative. Numerous other steps and events would have been necessary before they could be considered positioned to adopt. A speculative injury does not satisfy the injury in fact requirement. Could you comment on that?
And I do understand that, but I still try to make the delineation between how are these interveners classified. By virtue of the trial court permissively joining them to the case as petitioning adoptees, they were at that point no longer foster parents. We don't dispute that foster parents do not have an expectation of continued contact, and had they been involved in this case merely as foster parents without taking that extra step of opening additional cases, paying a filing fee, and filing separate petitions to adopt, they likely would not have a cause of action. However, again, the language of 19.5202 does not put such a requirement on someone petitioning for adoption.
But 19.52071 puts the authority on the department to consent. And that went to my question. Do you agree that the department has legal custody?
I have made the same argument in trial, and I'll make the argument today. I believe that the court vests the authority in the department to make decisions that are in the best interest of the children. And when the department declines to do that or stops acting in their best interest, the court does have the ability to divest them of that authority, and that's where I would reference again NRA, or people in the interest of M. I believe again that this trial court found that our department was clearly not acting in the best interest of the children in stating openly that they were. Sure.
Sorry, I'm interrupting again, but let me ask, the department still has legal custody. The court did not take custody away from the department.
Well, it depends on, as of right now, there's a stay. After the ruling on June 20, that derived from the June 25th and 26th hearing, there was to be a transfer of custody to the interveners. However,
Well, that would be physical custody, not legal custody.
I did prepare and file a notice of adopt, and I believe they did transfer the custody to the interveners pending that adoption. However, as the court will recall, there is a stay on that right now. But I think that we run into a very dangerous road if we say that the department, who may or may not be acting in a child's best interest, should be allowed to have that authority, even if it's clear that they are not acting in their best interest. I think that does a disservice to the children of Colorado to allow an adversarial department to assert their authority and usurp the position of the trial court, who I believe is the supreme power that has the ability to determine what is in a child's best interest, even over the objection of an adversarial department. Would you like me to continue?
Sure.
Okay. I would like to just move on to the ICWA portion very briefly. There was some discussion today regarding whether 25 USC 1911 applies. And Mr. McLaren did discuss some information about there being no definitions of what these 4 different types of proceedings are, and I would maintain that that's actually not accurate. 25 USC 1903 very clearly does define these different proceedings, and I think there might be an issue of language that the court might want to look at with regards to when a termination proceeding is done. And under 25 USC 1903 subsection 1 small 2, it does state that termination of parental rights means any action resulting in the termination of the parent-child relationship. It seems to me that these parties are maintaining that despite there being no written order made or no written motion being made in November of 2017, that somehow told the department or the Navajo Nation's request to transfer jurisdiction, and we maintain that that's not accurate. What we maintain is that the Navajo Nation very clearly could have requested this transfer prior to adoption petitions being filed, and that my clients would have been at a disadvantage and likely would have had no cause of action. However, they chose not to do that. They did not ever file a written motion in a timely manner. They waited until after the adoption petitions were filed, and I believe the trial court even referenced that it appeared to be an attempt to preclude the interveners from pursuing adoption. And so we have a very interesting situation where I don't think anybody questions whether or not the department and the interveners have an adversarial relationship, but they want to preclude them from participating in the DNN. They want to preclude them from participating in the ICWA proceeding. They want to preclude them from being able to try to adopt, and they also want to preclude them from participating in defending an appeal when they prevailed at the trial court level. And to me, again, that seems like they're attempting to assert that the law allows the department and the Navajo Nation to usurp the authority of the trial court, and I think that's just not on point, sirs. With regards to the Navajo Nation...
Ms. Carlson, could I
Sure,
interject again? I'll ask you the same question I asked opposing counsel. Is it your position that 19.126.4b creates a presumption in favor of transferring jurisdiction?
I don't believe it does. I think the plain language of 19.126 subsection 4 does require the court to make that consideration, to look into these things, and to give some credence to the BIA guidelines and the ICWA provisions. But I do not think there's a presumption established, and there's certainly no mandatory requirement for transfer, and to represent so is just missing the mark as far as the law is concerned.
So what role does good cause play in the determination?
I think it plays into the trial court's ultimate determination that they have to do what is in the best interest of the child. And by opposing counsel's own admission, the ICWA BIA guidelines and the ICWA statutes do not address best interests of the child. It's a global thing that's included, but Colorado courts and Colorado law requires our trial courts to make a determination of the best interests of the children, and they are to consider all factors. And I would argue that that's how 19.1.126 subsection B4 comes into play, where it is merely but a consideration that's made with regards to the best interests of the child in cases where there are Indian children involved. I don't know if anybody else has any other questions.
In making that consideration of best interest in resolving a petition to transfer, is the trial court permitted to consider what it anticipates will be the outcome if it transfers jurisdiction to the tribal court?
I don't believe they are. However, as your honors will know, in the order, the judge did discuss that because that the ultimate determination of where the Navajo Nation wanted to place these children was brought up in court, and the judge did say, I don't think it's appropriate for you to open the door and then say, no, you can't come in. And I think that's precisely what the Navajo Nation attempted to do here, was to open the door and walk the judge into a situation where he would potentially have an appealable order. But I believe the trial judge ruled correctly in saying, if you're going to present it and open the door, I'm allowed to address it. But no, ordinarily, I don't think that would be something that should be considered.
So wouldn't the appropriate response to that effort have been, this is an inappropriate consideration on either side of the ledger, and for the trial court to have just not considered that at all, as opposed to really then taking that invitation to go down a path that appears to be prohibited by the guidelines?
Perhaps, although I would also argue, along with what the trial court said, that those guidelines are not binding upon the court, and I believe that they are simply guidelines. If it was inadvisable for him to include that portion, then it was inadvisable for the Navajo Nation to submit it to the trial court as evidence in the first place.
I don't necessarily disagree with that. I'm trying to figure out, we don't review parties' decisions as much as we do the court's decision, and I'm trying to figure out how that factored in and what we do with it, given that it seemed to be a very weighty consideration.
I don't know that I specifically have the answers to that question, sir, and I wish I did, because I think that, I know that you've reviewed the record. I think part of where the court was going with that was there was some concern about the safety of the children in that placement, but I would argue that even though the court may or perhaps should not have considered that, the court still has the overarching policy goal of doing what's in the best interest of the children. And when notified that there's going to be an action potentially taken that's not in their best interest by a party who brought it to the table, I think the court was right to address it.
But won't the Navajo Nation, if they assume jurisdiction, they've got a similar obligation to the trial court, the state trial court, to act in the children's best interest. It's just a different tribunal that's exercising that judgment. And I guess I'm trying to figure out where the line between acting in the best interest of the children versus assuming that the trial court is in the better position to do so lies. And that really, to me, strikes at what the core of ICWA is designed to do and to protect against.
If I can be slightly discussing the facts, just to hone the court's attention to why I believe the judge made that call. This was an issue about interstate compact on the placement of children, and the proposed placement was a placement that would have not been allowed under the state of Colorado, but would have been allowed under the Navajo Nation. And I think that's where the concern lies, that the restrictions and the requirements under the ICPC were not as stringent and could have potentially put these children in danger.
Well, and that's the very concern, is that we all know that there are various reasons why various placements may not pass muster under the IPC, under the Interstate Compact. Some of them are meritorious and are there for good reason. Other times it's a technical defect that may be a reason that the department can't place, even though it would like to. So this seems to say we are substituting the Colorado court's judgment and state law for what we're concerned that the separate judgment, also driven at deciding on the best interest of the children, as exercised by a tribal court who is not saddled with the same administrative requirements, would do. And therefore, it's based on the potential outcome and the way in which a tribal court would exercise its judgment then becomes the lens through which a transfer question of jurisdiction ends up ultimately being decided, which to me, again, goes to the core of what we can and can't consider in determining these ICWA transfers.
And before you answer, did we add the 3?
You did.
So I see you're out of time, but go ahead and respond briefly.
Sure. I would just respond with perhaps it's correct and perhaps there needs to be some clarification on what the court under 19-1-126 can or cannot consider. However, that's not an issue when this case was being tried, and it's just but one factor of all the factors this court considered in making a determination that what the Navajo Nation and the department were requesting was not in the children's best interest.
All right, well, thank you, counsel. Each of you has done, in my mind, an outstanding job in presenting your arguments, both in the written briefs and at oral argument. The case will stand submitted, and a written opinion will issue in due course. The court will be in recess. The court will be in recess subject to